Our next case is People of the State of Michigan versus Joshua Meathoff, 2, and operating while intoxicated is a third offense, and possession of a firearm while under the influence. And then attached to that were several letters. We have one from Dr. Deere talking about its progress there. And there were some other statements or letters here that I received. All right, allocution. I'll start with Mr. Denham. Sir?
Thank you. First, the people, I guess I'll start out positive. I'm not aware of bond violations, any bond violations. So give credit to the defendant for that. I think that he's been performing well on bond. However, the defendant did receive a significant benefit of the plea agreement. We did dismiss the felony firearm count. I support the recommendation. The incident itself involved allegations, be on the lookout call. Allegedly, the defendant was all over the roadway. Ultimately, he was found at the local Wesco. He was somewhat non-compliant. When the blood draw was done, which was approximately 2 hours after the incident, so a significant period of time had elapsed, he still had a blood alcohol content of 0.239, which is, as the court is aware, about 3 times over the legal limit. So significant.
Right out of the gate, this case gets serious. A blood alcohol level of 0.239 nearly 2 hours after driving is incredibly high, and prosecutors aren't just talking about drunk driving anymore. Add a loaded firearm into mix, plus multiple prior OWI convictions, and the judge is already looking at a pattern instead of a one-time mistake. Here's the question. If someone has already been caught drinking and driving multiple times, how many chances should the justice system give them?
Steve, I think we need to let him finish out.
Hold on just a minute. Go ahead, Mr. Denham.
Okay, so significantly over the legal limit. There was a loaded gun in the vehicle. There were vodka bottles, at least 2. The PSI report notes that there's been a series of drinking and driving convictions in a relatively short span in the last few years. The defendant, I guess, breached my radar and of some concern on the 2024 incident, the failure to report an accident. That involved the defendant running into the backside of a manure spreader that was going 33 miles per hour at the time. He went into the ditch, went through the windshield. Witnesses indicated that blood was coming from his nose. So that raised some concerns for the people, given that scenario. He was not at the scene, so he was not charged. I'll leave it at leaving the scene of an accident. But certainly that raised some additional concerns separate and apart from the OWI convictions. I do support the recommendation, Your Honor. I would respectfully request the court follow the recommendation of the probation department.
We also recognize that my client received a significant benefit from this plea. We realized there was an absolute minimum sentence as it was charged that would have sent him to prison. We're very glad that's not happening. He's cognizant of that fact here today. He is employed, as the court did note, at Sara Lee Factory. He reminded me earlier this morning his shift is from 2 a.m. to 2 p.m. Quite the fun shift. I've done a few of those myself at different locations, or things close to them, maybe graveyard shift is my point. We would ask the court to fashion a sentence where he could maintain that employment and do the jail sentence on the weekends. We realize there's a minimum 30 days here, and the court can go above that. But I know sometimes the court does allow, with its grace, to allow my clients to do 48-hour chunks on the weekends. And even though I've informed him you most likely would want a GPS tether on him as you've done in the past, he would be willing to comply with that. He very much so wants to keep this job. He's informed me he has the support of his coworkers. He wants to continue to show them that he can be a good colleague, have his job so that he has good support structure when he gets done with the term of probation, that we don't doubt Your Honor will give him probation as well. He also continues to have the support of his family. I know some friends and family wrote letters. Others, I'm informed, still support him, but just didn't quite get the pen to the paper, but are definitely still there. They may or may not be watching right now, in fact. I would also ask the court to consider allowing him a week before starting any jail sentence so that he could tell his employer exactly what's going on. He was honest with them, he tells me, but because he didn't know exactly what the sentence would be, he obviously wasn't able to communicate that. So if the court give him a little bit of grace before the first day in jail, we'd appreciate that as well. As was noted a moment ago, he may or may not wish to make a statement. That's at his discretion. I've given him my advice on which things may or may not be the best to say. I realize this was a no contest, so I won't overly allocute. I know the court has to take everything in the report as accurate, but because it was more for lack of recollection and civil liability. If he suddenly had better recollection, I just ask the court to factor that in. Thank you.
All right. Mr. Meekoff, you have the right to make a statement if you so choose.
I guess all I've got to say is that night was 35-mile-an-hour winds. It was windy. I hadn't drank until I was at the parking lot waiting for my ride to pick me up. Vehicle was off, and the person picking me up did speak to the cop on the phone when he approached me, I was on the phone with them. I guess that's about it. Again, if I could somehow maintain my job, that'd be great. Or if not, I understand.
So, okay, I'm sorry, keep going.
I guess a week or so I could get my house arranged. That way I could let my landlord know that I'd be leaving the property or whatever.
Whose vehicle was this?
Well, it was my mother's.
How'd you get it?
I was working on it.
How do you get to and from work?
I get picked up. I carpool. That my mom will take me to work.
Oh, this is the exact moment defense attorneys hope never happens. The defendant is introducing facts that directly conflict with the no contest plea he already entered. Legally, that's a huge problem because the judge isn't retrying the case. He's deciding the sentence. Once credibility starts slipping, everything else becomes an uphill battle. Do you think he was genuinely confused or trying to rewrite the story?
How is it that you remember this now and you didn't remember anything last time I took the plea 2 months ago?
I guess I didn't really quite understand everything.
What do you mean you didn't understand everything?
As in like the no contest or
I
whatnot.
explained it to you. I told you couldn't challenge what was in the report.
Right.
How was that not clear?
I guess I just wasn't. I mean,
You weren't being honest with yourself or with the court, because I'm pretty clear when I do a no contest plea.
Right.
And you told me you couldn't remember. Which means if you try to tell me you remember stuff, I think you're lying. So I don't know. There is no better way to explain it than I do. I'm pretty sure. I'm not patting myself on the back, but I say you cannot challenge what is said in here. And so I don't care if it was windy. You were obliteratedly drunk, swerving, putting people in danger. Whatever you've been telling yourself prior to sitting there in that chair today is wrong. Your hopes are not going to be met. You will be leaving through that door in about 4 minutes. You are not going to go to work and say, and give you another week. I don't know what the heck you've been doing in the last 2 months if you didn't tell them that was a possibility. That does not matter. You are 31 and you have 3 drinking and drivings within 6 years. And in this instance, you were all over the road enough that people called police.
And just like that, the mood in the courtroom completely changes. The judge has made up his mind that this isn't about one bad night. It's about repeated dangerous choices. When a judge believes a defendant is minimizing responsibility instead of accepting it, requests like weekend jail or delayed reporting become much harder to justify. This hearing is no longer about sympathy. It's about accountability.
You were driving when you could not drive a car. You were unlawful for you to drive a car. And it was unlawful for you to possess a firearm. Am I right?
loaded firearm.
Yeah. No. You're not going to let you go hunting. You can't possess a firearm. You can't possess a loaded firearm. And you were drunk with the blood alcohol level that would put most people in bed for a couple days, passed out. Oh no. I really hope what you told me was the truth. And if your mom's out there watching and she thinks to herself and she goes, well, I kind of let him have it, borrow it. It's her fault then that you got it. If she didn't, then that's not her fault. It's only your fault. I don't want to be insulting to your mother, but I'll tell you, if somebody else was letting you drive their car, they were wrong. Had you killed somebody, it would have been on them too. Yeah. No. I appreciate you've been going to AA. That's great. Because you need it. Now I'm also looking here, and there's some issues here about, depression and anxiety. I don't see any medications of treatment because apparently you are treating everything with alcoholism. And you began using at a young age. Age 17, 3 to 4 times a week in the last 13, 14 years. Wow.
Notice how the judge keeps coming back to one word: credibility. Courts can work with addiction. They can work with people asking for help. But it's incredibly difficult to work with someone the judge believes isn't being completely truthful. In sentencing hearings, honesty can sometimes matter just as much as a crime itself.
You set yourself up for failure.
Yes, Your Honor.
So, and I'll tell you why I talked about credibility. And that's what I jumped on right away when you started telling me about what you remember and then telling me I didn't do a good enough job explaining it to you. Well, you had a 3/4 empty bottle of Smirnoff in the car. But actually, there are 2 bottles. You lied to the cops about what you had been drinking. So again, 31 years of age, and your criminal history began about 15 years ago. Unlawful driving away of a motor vehicle and malicious damage of property. You were given a chance. Then you have this fail to stop at an auto accident. Then you have in 2019 an open intox in a vehicle and violence charge, although there's only an open intox. Then in 2020, sure enough, open intox and drinking and driving. 2022, open intox and drinking and driving. And then 2023, driving a vehicle while your license was suspended, denied, or revoked. I'm not going to ask, and I don't want you to answer because it ain't going to go well. Boy, I would like to know whose car that was. And then in 2023, which was while you were on probation for the last one, you picked up another driving license suspended, which means deception. You're going to do whatever you want when you think no one is looking. And then 2024, oh my gosh. Failed to report an accident and driving license is suspended, denied, or revoked. Now that charge was dismissed, but if you fail to report an accident, it doesn't take much. It's a logical conclusion that you were driving while your license was suspended. And I would love to know whose vehicle you were driving those times. Who's ever allowing you to drive their vehicles? It's too bad on them. And now here you are in about a year, and you've got felony firearm, R&O, which I know those were dismissed, the possession while drunk, operating while your license is suspended and not revoked, which I know that was dismissed, but I can tell if you were drinking and driving, you were driving when your license was suspended. So I've got deception, alcohol, and violence wrapped all into one here.
This is why prior convictions matter so much. The judge isn't sentencing only today's offense. He's evaluating years of decisions. Every previous OWI, every suspended license, every missed opportunity adds another layer to the final sentence. Would you still recommend probation after hearing this record, or is jail the only realistic option? Let us know below.
So, yeah, it might be a good employee, but boy, I would never let you walk into my place of business or work without giving you a breath test every single time. So I appreciate that you're getting the help here, and that's great. And I'm going to help. So at the age of 31, you realize your days of consuming alcohol are without a doubt done. Because if you do it again and you get caught, your only next place to go is prison. And I would have no problem sending a 4th drinking and driver to prison.
Yes, Your Honor.
The court sentences the defendant as follows: 36 months of probation. You have the right to be considered for early release from that probation at halftime if you are successful with the terms and conditions of that probation. In this particular file, the court sentences the defendant to 12 months in the Missaukee County Jail. The number one thing you did wrong. The number one thing you tried to do today was try to tell me, oh yeah, now I remember, and I wasn't told well enough what was going on. I didn't understand. I don't believe you. Don't talk. You're gonna make it worse. Just put your initial on that one page. The sentence is well within the guidelines. This is a straddle cell. The court could easily send the defendant to prison. And you're gonna note one thing. Had I sent you to prison, you could have gotten boot camp. You probably could be out a lot faster than you will be when you're going that way.
And that's the final takeaway from this case. The judge actually spared the defendant from prison, but still imposed a full year in county jail because he believed responsibility was never fully accepted. One sentence summed it all up. Blaming it on the wind was a bad choice. In court, excuses rarely reduce punishment, but genuine accountability sometimes can. What do you think of this sentence? Was the judge fair, too harsh, or exactly right? Let us know in the comments.
Thank you, Mr. Hartel. Blaming it on the wind.
My client has asked me to ask the court. I know the court.
No. Going to jail. It's not on weekends. You're going to jail. Blaming it on the wind, that was a bad choice. Thank you.